Hi, Emma, and hello, Your Honor. It's very nice to see you guys.
Nice to see you.
Hello.
Well, we're here today to talk about a recent case that came out from the Supreme Court, which is not very usual to see a youth case coming out of the Supreme Court. So this was a very exciting and important case in youth criminal justice, and that's the case of IM that was recently released. And we're going to be talking about what this case is about and its implications. But before that, we'll just start with some general talk about what is it that the case was going to be talking about, or the main subject of it, and how things were before in the previous Section 72 and how things are now with the current version of this section, because really this case centers around Section 72 of the Youth Criminal Justice Act. So I think, Your Honor, you're going to start by giving us a bit of an overview, if you can.
Of
I'll
course.
take notes too because
Yeah.
All right. Well, for anyone who's not very familiar with the Youth Criminal Justice Act, let's just start, maybe with some very basic principles to begin with. Parliament created a separate statute, right, intentionally, so that we address youth crime differently than we address adult crime. And the Youth Criminal Justice Act has been in force since 2003. Really, one of Parliament's primary goals with this legislation was to reduce the rates of incarceration for youth, really across the board. It did, however, include certain exceptions to that. So it is possible, of course, to receive a custodial sentence even when you're sentenced as a youth, when you commit an offense between the ages of 12 and 17, although there are restrictions in the statute that limit when that's possible legally. Primarily, it occurs when a young person has committed a, quote, violent offense, as that's defined in the statute. Now, in a very small number of cases, when certain criteria are met, the Crown can apply for an adult sentence for a young person. So a young person is still tried in youth court. There are no transfers to adult court. That was something they did away with when we moved from the Young Offenders Act to the Criminal Justice Act. But if the Crown puts the young person on notice of their intention to seek an adult sentence, and in certain rare circumstances, then at the end of the proceedings in youth court, the judge presiding can impose an adult sentence if they believe those criteria have been satisfied. These cases, IM and SB, are so fascinating because they're the first time the Supreme Court has addressed this test for an adult sentence and what the Crown actually has to prove and on what standard in order for an adult sentence to be imposed. Prior to these decisions being released, there was some dispute or conflict amongst provincial appellate courts in this country about exactly what the test was under Section 72 of the Youth Criminal Justice Act. As a starting point, it's important to remember that back in 2008, in a decision called DB, the Supreme Court recognized as a principle of fundamental justice under Section 7 of the Charter that young persons were entitled to a presumption of diminished moral blameworthiness or culpability. Right? That presumption applies simply by virtue of their chronological age. The fact that the offense occurred when they were between the ages of 12 and 17. If you're younger than 12, you can't be charged with a criminal offense at all. That presumption was then codified or added to the statute in amendments to the act that came into force in 2012. And it's currently found in Section 31B of the Youth Criminal Justice Act, which specifies the criminal justice system for young persons must be separate from that of adults and must be based on this principle of diminished moral blameworthiness or culpability. So that is why, of course, we have a separate sentencing regime for young persons, in part to recognize this very important and constitutional principle. What the Crown can do when a young person is at least 14 at the time they committed a criminal offense is that it can apply for the court to sentence the young person to an adult sentence if two criteria have been met. So 72(1)(a) says the presumption of diminished moral blameworthiness or culpability has been rebutted. And that's really, I think, the most important takeaway from these cases that we'll talk about. And then B, that a sentence imposed under the provisions of the Youth Criminal Justice Act would, quote, not be of sufficient length to hold the young person accountable for his or her offending behavior. So what the Supreme Court was able to do in both of these cases, and particularly IM, was finally decide and provide clarity to the trial courts, right? What is the standard that has to be applied when the Crown makes an application for an adult sentence? And the very short version of what these cases stand for is that the Crown faces what the Supreme Court calls is a heavy onus to rebut this presumption of diminished moral culpability. And the Supreme Court creates a distinction between one's chronological age and their developmental age. And the main ruling of the decisions is that the Crown must prove beyond a reasonable doubt that a young person's developmental age is actually that of an adult in order for the presumption to be overcome. It's described as a factual inquiry primarily, and the Supreme Court goes out of its way to say, I don't think this is really controversial by itself, while age plays a role in the development of judgment and moral sophistication, chronological age and maturity may not be one and the same. And I'm reading from paragraph 104 here of IM. In connection with the rebuttal of the presumption, it is important to note that a young person's developmental maturity does not necessarily coincide with their chronological age. So what the Crown has to prove, not really focused on the circumstances of the offense. In fact, Justice Kazarur goes out of his way, I think, in the rulings to say, you cannot place undue emphasis on that. Indeed, generally speaking, the circumstances of the offense are almost not relevant to this inquiry. Instead, what the Crown has to demonstrate is that sort of independent of the crime that the young person has committed, that the young offenders, excuse me, oh, that was a big note. I can see Emma frowning already. Sorry.
So that's one of the things. Okay, so and Your Honor, I'll let you go back to your thing. This is one of the things that I really struggled with this decision, and I did fangirl over this decision. I won't lie. Like, I was all excited. I loved it. I was like, yes, yes. As I say over and over again, anytime a judgment or a lawyer refers to a young offender when it's a young person that wasn't dealt with under the Young Offenders Act, an angel loses its wings. And I got to tell you, many angels are not making it to heaven because of this decision, because the Supreme Court of Canada did say young offender throughout. They were not dealing with youth under the YOA. It was YCJA. The proper legal term is young person. I'm going to forgive them because perhaps they'll say, oh, because they were found guilty, then they are technically a young offender. But I don't think so. They are just a young person where there's been a finding of guilt. We as lawyers, as judges, we have to be very careful about not using the term young offender, because that is a specific legislative term referring to youth that are dealt with under the Young Offenders Act. And so that really bothered me. The word convicted really bothered me, because youth, unless they're sentenced as an adult, and in this one, they are very specifically not. That's the whole point of the decision. The term convicted was also used. And again, many angels are not going to heaven as a result of that, because that was used throughout the decision. But youth are not convicted unless they're found guilty and sentenced as an adult. There's findings of guilt. So those were two things where it was like I had an eye twitch when I was reading it every time it came up. So that was my major, I would say one of my only difficulties with the decision, or the thing that really bothered me, was that, listen, it's 2025. The YCJA has been in effect since 2003. It's time. We should get the language down. It's young person, finding of guilt. Okay.
In my limited defense, my snafu there was because I was reading from a paragraph of the decision where the Supreme Court uses that term. But
yeah, well, but that proves that we don't have too many youth cases in the Supreme Court, right? So that proves
very few.
Yeah.
And so it is, and that is like another part of the issue, right? Is that people think that, oh, if you know criminal law, then you can represent young people under the YCJA. And it really shows, no, actually the YCJA is very distinct. It's a very specific piece of legislation. And just because it's like, as I say as I explain, if you have a brain injury, you're not going to go to a foot doctor. And it's kind of the same thing. They are two different things. And the Supreme Court has said that in this decision. But anyways, I went on my little rant. Your Honor.
All fair observations, and I apologize again for my mistake.
Yes, as judges,
if the Supreme Court can do it, what hope is there for me? But to continue with my thought, in order for the Crown to rebut this, it's going to be, I don't think this is controversial either. It's just going to be challenging, okay? Potentially very challenging, because what the Supreme Court says the Crown has to do is convince the youth court that the young person possessed, quote, adult-like maturity capacity for moral judgment, and independence. Okay? And there's a lot of language in this decision that explains what they mean by developmental age. Okay? It's a factual inquiry, but it looks at someone's psychological, social, and moral maturity, again, independent of the crime. In paragraph 141, the Supreme Court says that generally speaking, the seriousness of the offense has no place, that's their language, not mine, in this analysis. I think the best sort of, pithy way of stating this I heard from Nader Hassan when he was interviewed after this decision came out, which is that a child who commits a terrible crime is still a child. And that's really what the decision, I think, stands for. And while it is not impossible to rebut the presumption, and in the SB decision, the Supreme Court was satisfied that the presumption had been rebutted, it will inevitably be a difficult hill for the Crown to climb, because of course we don't normally ascribe adult maturity or sophistication to young persons. Right? That's why that presumption exists. I think anyone in their daily lives would agree with that in general. Where it can become challenging, I admit, is sometimes people sort of get fixated on this idea, well, that if a young person commits, quote, a very serious crime more commonly associated with adults, shouldn't there be a different sort of penalty for them? This is a matter of law, saying nothing else. Our system says, no, they're still sentenced as a youth, unless in these very rare circumstances, that presumption is rebutted. The other main takeaway from the decision is just the second prong of the test does not require proof beyond a reasonable doubt. It's simply satisfying the court that the youth sentences that are available would be insufficient to hold the young person accountable. And there's a lot of discussion in the decision about what that means. Accountability as a concept and factors the court should be considering when assessing that. As Emma, I'm sure, would also tell anyone who's interested, there are a lot of really unique sentencing options under the Youth Criminal Justice Act that don't have an equivalent under the criminal code. So there are many options that really have to be thoroughly considered, even at this prong, I would think, of the test, even if the Crown somehow manages to clear that first prong.
And it's interesting how the Supreme Court talked about that, right? About the seriousness of the offense not being the determinative factor, because they said, listen, if that was the intent of the legislators, then there wouldn't be a different sentencing regime or a different sentence for youth under the YCJA who are found guilty of first or second degree murder. And so I really liked that reasoning. It's just like, we wouldn't even have this. And even if a young person is sentenced as an adult for those serious offenses, the parole is different. So the legislators clearly said, or were clearly making like the seriousness of the offense. If it was just this assumption that if it's a very serious offense that a young person is going to receive an adult sentence, then we wouldn't have all these distinctions in the act. So I really liked how they teased that out, and I thought that was just again, I was fangirling over that. I really liked how the Supremes did that.
So it provides a lot of clarity in many areas where I will sort of respectively observe that maybe was lacking based on some of the conflicting appellate decisions in the country beforehand. In that sense, it's a very helpful decision, both.
Yes, I mean, like this is one of the good things about that decision is that it really clarifies Section 72, the standards of proof and the prongs, and that they should be analyzed differently. And Emma, you were touching on some of the things that you like about the decision, but did you like everything, or were there some things that you disliked other than the? Yeah,
that was my main thing, where every time I was just like, oh, and I had a little bit of a twitch, and I was like, no, keep reading. But I really struggled with that. And the reason why I struggled with that language is because the language is different, and so it's just that I really struggled with that, because it was just, the language. The language is so important. And so, and we still see this in judgments regularly. We see this when ministers of justice are talking about young people that are charged. We see this in police notes. And it's something that's really frustrating, because prior to the Young Offenders Act, there was the Juvenile Delinquents Act, where the youth were referred to as juvenile delinquents. So why don't we just say juvenile delinquents? Of course we wouldn't. It's ridiculous, because we're different legislation. But the use of young offenders should have that same kind of no. Young offenders we only refer to that if a young person has been, or a young person is dealt with under the YOA. So it was something that I twitched a lot.
And is that the only thing that really bothered you? Otherwise,
main one. His Honor brought up a point that I actually didn't even twig to until, or something, it's not something they disliked, but something that may create confusion. And once he pointed it out to me, I was like, oh yeah, actually that may be an issue. So perhaps His Honor can discuss that.
Sure. So one question that remains unanswered for the time being, which the Supreme Court felt it didn't have the proper record to decide it, is how does pre-sentence custody get factored into some of these determinations? In particular, the second prong of the test, what's an appropriate sentence to hold a young person accountable for their actions? What ends up happening, of course, with IM is initially sentenced to an adult sentence, serves a period of time in, I can imagine, penitentiary. That time between the day they're found guilty and the day their appeal is decided by the Supreme Court is credited against the appropriate sentence. No dispute about that. But what about the time they spent in custody prior to that initial finding of guilt? Because they've been detained since their arrest. That was not an insignificant period of time in this case. And how pre-sentence custody should be considered on these applications or just factored in more broadly is something that has also been a little unclear in the existing jurisprudence. For example, is it lawful for a youth court when deciding one of these applications to say, well, you've spent so much time in pre-sentence custody, I will give you 0 credit for that and then give you the maximum youth sentence available on top of what you've effectively already served in order to find a sentence that would be sufficient to hold you accountable without having to actually use an adult sentence to meet that test? Or is that inappropriate? Is that effectively sort of circumventing the will of Parliament and imposing a longer sentence that was originally envisioned? I was really hoping they would answer this question as well. They decided not to, and they simply observed that the jurisprudence in respect of what Section 38 sub 3, I believe, of the statute has generally emphasized the importance of the discretion of the youth court sentencing someone to grant or deny credit as they deem fit to fashion an appropriate youth sentence that is, quote, responsive to the needs of the young person. I'm reading from one of the paragraphs right now. To me, that leaves a lot of questions still unanswered. Does that mean that I have discretion as a youth sentencing judge to effectively grant no credit or very little credit, or in other cases, perhaps considerable credit, simply as I see fit, in order to come out to, quote, a youth sentence that is responsive to the needs of the young person? This isn't something really we sort of see in adult court. It's just sort of presumed that people get summer's credit, if not perhaps even extra credit sometimes, based on the conditions they're facing. But now in youth court, as I interpret this current, always open to being corrected in the future, is there more discretion being potentially thrown to youth justice courts, especially when an adult sentence is being applied? Or is this only when an adult sentence is being applied? Quote, in a standard youth sentencing case, is my discretion perhaps more curtailed? Those questions to me remain unanswered as a result of these 2 decisions, although I imagine we're going to see a lot of future litigation on those points in specific.
And so that dovetails into my question, which is the Ontario Court of Appeal decision of MB and how that gives discretion to sentencing judges when sentencing a young person of whether or not they give any weight to pre-sentence custody, and especially when trying to avoid a youth sentence. So if the determining factor now is whether or not the young person had the intellectual capacity of an adult, is MB good law now? Or has the Supreme Court essentially overruled that decision? Because now it's not like, oh, I need to find the most appropriate sentence because of the seriousness of the offense. Now it's like, is the youth operating like an adult or not? So I would argue, I don't think MB is good law anymore. And so I think that is something that we're going to see litigated, or I hope we see it litigated. But I think that's one of the doors that these decisions, these twin decisions, opened up.
And one of the first cases, presumably, we'll see is that IM still has to be sentenced, right? It's gone back now to the Superior Court judge who heard the case originally, is my understanding. And this whole issue of whether or not pre-sentence custody should be factored in to the remainder of any youth sentence has to be determined at that level of court again. So hopefully we'll have a decision from that court as soon as possible. But I agree with Emma, this is going to be an area of future litigation.
But so then, how is this going to impact then youth cases moving forward? So we still don't know how in the case of IM, he will be sentenced. But in general, what are the implications? I mean, one thing that I find striking personally in Section 72 is that once we do have these two prongs that are satisfied, then it shall apply. Like it's mandatory, which I find is pretty scary because I mean, it's a good thing that the test is hard, but once we pass it, that's it. It does apply. So
it's interesting, right? Because I think on the ground, when we're just, I don't think it's going to look different. And the reason why I say that is that a Crown is required to give notice at the earliest opportunity that they're seeking an adult sentence. That is, without a doubt, going to be done on the basis of the seriousness of the offense.
Yeah.
If we have a really mature 17-year-old, they're not going to be who's operating like a 22-year-old. We're not going to have unlikely that we're going to have Crowns seeking adult sentences or giving that notice for a robbery or something like that, unless there's a serious injury involved. So I think on the ground it's not going to look it's going to look exactly the same. What's going to be interesting is the justification for that, when there is, at that point, the Crown won't have any evidence whatsoever that the young person is operating or has the mental capacity of an adult. So I think on the ground it's going to look the same, but I would argue that it's maybe intellectually dishonest to do it that way, because the test is whether or not they have the evidence that a young person has the capability of an adult or has the intellectual capacity of an adult.
But let's talk a bit, though, about the evidence, because what is it the Crown has to specifically show then to prove that this young person is operating like an adult? Because it's on the Crown. It's their onus.
Well, it is the Crown's onus, absolutely. I mean, I don't think any of us would be, going outside the four corners of the decision to say this is going to be extremely difficult for the Crown, because what the Crown normally has up front is the nature of the offense. Can I prove this offense happened? And is it, objectively speaking, very serious, like a murder, which is what happened in these two cases? Of course, the answer to that is yes. But the Supreme Court has now said, well, that doesn't really matter. In a limited capacity, it matters if there's evidence of planning or sophistication behind the offense. That can factor in, the Supreme Court does say. But beyond that, we're talking about, again, evidence that would speak to the young person's developmental age. Obviously, just raw intelligence would be a factor, but also psychological, social, and moral maturity. The Crown will typically not really have access to that kind of evidence.
Exactly. They're not their clients. So
it's very difficult, I think, for the Crown to make these decisions. I mean, they will probably say, look, the seriousness of the offense isn't totally relevant. That's fair. So it's still something we're concerning, but we can't make the decision or decide if the decision should be sought through to the end until we get some information from, for example, the Section 34 assessment is ordered, although the Supreme Court didn't say those were mandatory. And of course, the Crown can always back down. If they prove the offense and they prove the young person was guilty, and they put the defense on notice of an adult sentence application, and then by the conclusion of the sentencing hearing, the sum total of the evidence is insufficient to overcome this presumption. I think in the finest traditions of that office, many Crowns then might, probably should in some circumstances, say we're now abandoning that application. It's just not here, not made out on the evidence. But on a good faith basis, I think they can at least explore that. One of the hidden gems in this decision, maybe not even so hidden, and I would recommend to everyone to read these paragraphs, especially, even if you're usually an adult court, are the comments about social context evidence. These are really important paragraphs, particularly for youth, but I can see them catching on in adult cases as well. The Supreme Court says explicitly that the social context in which a young person grows up can often affect the trajectory of their life, and understanding that trajectory helps place their decisions in context, potentially demonstrating increased vulnerability, diminished judgment, and a reduced capacity for moral decision making. Right? I think this is kind of just intuitively clear. We're all a product of our environment to an extent. And if someone has grown up with deprivation or dealing with systemic racism or other disadvantages, or perhaps has a mental health challenge or anything else, obviously that evidence is going to be very important to factor into whether or not the presumption's been rebutted. But I would think beyond that, just in general sentencing cases, even if everyone's agreeing it should be a youth sentence, really speaks to what is really necessary here to hold this young person accountable for what's happening. remembering that in youth courts, certain adult sentencing principles don't apply. General deterrence does not apply. Denunciation, very rare. Right? There's an exception in the statute, but it's very rarely applied. So I think some of these paragraphs are going to be very important for counsel to really work with in all youth cases going forward, and maybe potentially in some adult cases too.
And this
yeah,
has like my favorite, where I got very excited was in paragraph 166, where the Supreme Court quoted Justice for Children and Youth, who was, they were an intervener. And this is a sentence, I think, that everybody that's doing a youth sentencing court should take with them. And that is the idea that youth or gang affiliation for some youth act as a refuge-seeking response. And what a beautiful little tidbit to take in future sentencing, that, you know, a lot of times you see Crowns as saying it's aggravating that youth, that there is gang affiliation with the youth. The Supremes have said, actually, gang affiliation may be a response to the fact that the youth has a lot of challenges. And so that is it, not mitigating, but an explanation as to why youth are involved in gangs. It is a beautiful, beautiful sentence. And it's one that I think every lawyer should, and lawyers that are also representing adults, that this idea that gang affiliation isn't necessarily that the client is bad, or but it could just be a refuge, and a refuge from bad families, bad social connections, or lack of financial means. And so it may very well be that gangs are the only option for many youth. So that was a really, I got very happy when I saw that sentence. So paragraph 166, I think every lawyer should have that in their brief.
Let me just start before we move on, Maya. I'm just reading through a couple other paragraphs here. The Supreme Court specifically highlights these other factors as what should be considered when one of these applications is brought. So obviously their chronological age. I suppose the closer one gets to 18, perhaps the more merit the Crowns application will have. Their background, their sophistication in thinking, capacity for independent judgment. And anyone who's practiced in youth court a lot will know sometimes youth, especially young boys, make terrible decisions in groups, right, with other young people, where the ability to resist peer pressure is really difficult.
Well, but sorry, on that point though, what's interesting is that in this case, there were some adults as well who were involved. And so, so the planning here is just, it's not entirely by the youth. It's also, there are adults who are making them or guiding them towards these decisions. And so that also is a factor that should be considered. Yeah, go ahead.
I'm getting all excited because that was another point that I got really excited about with this decision, where they said planning by young people doesn't necessarily go to the fact that they have the mental capacity of an adult. Like, youth have brains, they aren't as high, but of course they're making plans. Like, of course they are.
But in this case, especially that there are adults as well who are doing the planning as well. So it's not 100% on the youth. There are some adults who should be also sentenced as adults.
But the idea that we can't expect youth to be, that they're just talking, they just think about second to second, where many youth do. But yes, youth plan. That doesn't mean that they are thinking like adults. It means that they're human beings, like a toddler can plan. It doesn't mean that they have the capacity of an 18-year-old. Well, so I really, really liked that. And I think that also is something that can give lawyers a lot of something to really back them up, that just because something is planned doesn't go to moral or heightened capacity. So that sentence really made me happy.
Well, and especially that in the case of a youth, even if there is planning, there isn't necessarily an understanding of the consequences of that planning. So that's why it's very different when it comes from a youth as opposed to an adult. We're expecting adults to know the consequences of their acts. So
and you're obviously both right on the money here. I was looking at paragraph 151. Susceptibility to external influences is a factor to consider in. One thing that it would have been maybe interesting to see if the Supreme Court had commented on this, they didn't, is how far can courts go in taking judicial notice of what we know about adolescent brain development? Like, in the scientific community, I've heard many experts testify over the years, and there's a lot of literature online about how the human brain continues to develop well into one's mid-20s. And it's the parts of the brain that deal with executive functioning in particular, dealing with peer pressure, impulse control, assessing risk and reward, thinking through the consequences of one's actions that are continuing to develop. So it's not just that the young people lack as much life experience as everyone else by definition of being younger. It's that their minds aren't fully developed, typically until one's about 25. Now, can I just take judicial notice of that as a sentencing court, or do I need an expert to actually testify? This is a really interesting open question still, in my opinion. And I think different judges have different views about how far it can go in this area. So that could be another area of potential future litigation as well. But regardless, the Supreme Court is clear that what they describe as both cognitive, emotional, and mental health must all be described. So of course you have the individual human being before you, what you know about them and their family. But these broader questions, I think, are also going to animate a lot of the future decisions here.
Mm-hmm. And it affirmed on paragraph 89, and another thing that I made that is something that I think all lawyers should carry with them when they are dealing with sentencing of a young person. Paragraph 89 affirmed that youth are constitutionally different for sentencing purposes. This is a big deal because in a lot of times you will see crowns or even judges say, well, an adult would get X for this. That has no place in youth sentencing because youth are constitutionally different. The Supreme Court again affirmed that. So I would suggest that if Crown starts making that submission, the answer or the reply to that is that's irrelevant. Youth are constitutionally different. This is apples to oranges. It has no place in sentencing a young person. So I got really excited when I read that. I got excited at a lot of places, but that was another one where I got very happy, where it's like, yes, youth are constitutionally different. The Supreme Court again affirmed that. And so again, defense lawyers, put this case, bring it up bring it up when you're involved in any youth sentencing, whenever they bring up that issue of, oh, this is what an adult would get. They'd be looking at a penitentiary sentence. The answer is, or the response to that is, who cares? It's apples to oranges.
Actually, I don't think that's controversial. So that's entirely correct. And the Supreme Court did very helpfully clarify that.
So I think, when we look at, any other doors that this potentially opens, the question that I would have is does this open the door possibly, or reopen the door, because other lawyers have tried to argue this, that for the young adult, so the 18 or 19-year-old that has the mental capacity of a youth or a child, should the principles of sentencing be different? So we saw that in YJCA, which is Justice Schreck's decision, where that was brought forward by defense. There was also a decision from Justice Malloy, but I don't, I have an idea of how that would end up. I don't think it would be successful, because we have driven this, line in the sand about once somebody turns 18, they're now considered an adult. But does that open the door, or should it open the door, that a young adult who does not have the mental capacity of an adult, but of a child or a young person, should the sentencing principles be different? And so that was something that I was thinking when I was reading this as well. Does that open that door to reconsider that issue?
I think it should.
I don't think there'd be any denying that developmental age as a concept is now entirely relevant at a sentencing proceeding. In other words, anybody get around that. The decision from Justice Malloy that Im is referencing is called RVDC 2025 ONSC 3462, where the argument by the defense in that case was, you can't just look at my client's chronological age. In fact, if you find that as a matter of developmental age, not perhaps phrased in those terms, my client actually functions as a child, then they shouldn't be sentenced under the Adult Criminal Code simply because they were chronologically an adult at the time they committed the offense. Now, Justice Malloy didn't accept that reasoning in that case, finding that chronological age still stands as a barrier for certain purposes, and that that age factor, as it is a developmental age issue, can be considered in sentencing. Query, do these decisions potentially reopen the door to that argument being successful in a future case? I honestly don't know, but I would encourage anyone who wants to think that through to read Justice Malloy's decision, as it's quite comprehensive.
But I think, sorry, I think it should apply, but of course the onus here will be reversed. It will be a defense onus in this case. It won't be on the Crown to make that argument.
The other thing in this case, if I can just add one further topic to our interesting takeaways from it is, while the issue in terms of the law about how to factor in pre-sentence custody now to sentencing decisions, especially when an adult sentencing application is brought by the Crown, remains a little vague, subject to further litigation, there is very powerful language in there about the detrimental effect that pre-sentence custody potentially has on a young person. So forget about the legal aspect. Just as a matter of fact, the Supreme Court writes that time spent in custody can disrupt education and social stability, often compounding the challenges faced by young persons. Obviously, the defense bar will want to latch on to that for obvious reasons, but I, as a youth sentencing court, have to consider this very carefully. I mean, I think other courts have already touched on this in decisions, but now it's stated clearly and loudly by the Supreme Court. Let's not lose sight of the fact that there are real adverse effects to keeping a young person in custody. It may be tragically necessary in some cases, obviously, but I don't think we should underestimate the real impact that this can have sometimes on young persons and their families. Particularly, I think, in cases where perhaps the local youth facility is a considerable distance from where the young person and their family live, and you may be effectively cutting off the young person from access to their community or their family if it's difficult to visit them. Maybe less of a concern in a large urban area like Toronto or YJCA, but certainly a big concern in other areas. I don't know. I thought that was some pretty powerful language. Emma, what do you think?
Yeah, with me, it's the issue with young people in pre-sentence custody, the issue of school and changing schools is just such a huge, that can really be the determination of whether or not a youth goes this way or that way, or which road they take, because disruption of school is not just, oh, they have to change schools, but disruption of peer group, disruption of adults that they see as support for them, and they may lose a year. And if they lose a semester, then they are then behind the people that or other youth that are in their age group. That can have a psychological effect. That can actually deter or be a deterrence for young people to continue with education. So, school for me is always the biggest factor. How do we keep youth in school? School is perhaps one of the biggest factors in rehabilitation and reintegration of young people. So, yeah, so that's just to dovetail off the pre-sentence custody issue. But we cannot underestimate the power or the effect that having that school has a young person and removing them from their school environment. Like that, it's just a huge effect.
Well, and also another thing that is different in the case of young persons is time is different. A year is a very long time in the life of a youth, and there are so many changes, so many developments that can happen. So, I mean, everything is very different. And there's a lot of rehabilitation that can happen in 1 year, or the opposite. There's a lot of deterioration that can happen. And so losing a year at school is really dramatic. It's huge in the life of a youth. So.
Yeah, it's huge. And the example I always give when I am talking about the different perception of time is, for teens, when you start school in September, the furthest thing from your mind is what you're going to do over December or the winter break. Like that is just a mile away.
Yeah.
You think of us as lawyers, like we are already setting our schedules for February, March, April, May. Like, we see this as happening, like we know it's going to happen in weeks, whereas youth are just like, no, that's a lifetime away. Yeah. And they're only talking about 3 or 4 months, where for us, 3 or 4 months is like, well, I need to start, getting ready for this now.
Yeah.
So it really does show the different perception of time. And it's always the example I use. Like, think about when you were in high school, it was first day of school. Were you thinking about December at all? Never, 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 never. Are we thinking about December in September? Always. So, it really does show the difference in perception of time. But speaking of time, like we've been talking about this for a while, and and I don't want to bore everybody with this because I kind of tap out with law as a lawyer. But I was, I'm very thankful for this opportunity, just because it was a break from Hockey Canada, because everybody's been talking about this. So this was a relief. So thank you for wanting to talk about this case, because I'm glad to be thinking about something else.
Well, I mean, just some final thoughts though, then, like this really is in the world of youth, it's a very important decision because Section 72 is a very important decision. It has a very major impact on a youth who to which this section does apply. But just one final thought here. Are we going to see more of Section 72, or is this going to effectively kind of reduce its application moving forward?
I know His Honor can't really speak about it, but I would say that it's going to be very difficult now, as it should be,
Yes.
for Crowns to argue for an adult sentence, to get that evidence that a 17, 16, 15-year-old is actually thinking like an adult. That's going to be very hard evidence to bring forward. So I think we're going to see, I'll be interested to see the first case where there is an adult sentence for a young person.
My final thought would just be this. If you're in youth court and you're making submissions about an appropriate youth sentence, these decisions have so much value, setting aside the adult sentencing aspect of them, which I understand is the core aspect of it. How the Supreme Court explains how we should measure accountability and the factors that should be considered when determining how to hold a young person accountable and how to assess their degree of responsibility are really, really important to understand. And go into youth court thinking about all of the unique sentencing options that exist. But you have so many creative arguments you can make in youth court that aren't available, unfortunately, in adult court. Things like the intensive support and supervision program, or in a very serious case, the intensive rehabilitative custody and supervision option. Things that should possibly be explored, but as lawyers, the first step is understanding them, understanding legally what they mean, and then understanding in reality how do you get the resources necessary for the assessments going to be done. I just think they're just tremendous bits of information in this decision that will just improve the quality of all sentencing decisions going forward for you. So don't think you only look at these decisions at the Crown is seeking an adult sentence. That's going to be rare. There's a lot in there that we should all be looking at for all young sentencing decisions.
100%. If you represent youth, you should be reading this decision. There are a lot of great little tidbits to take and use, and it's just yes. I was very worried about this decision, and I read it, and I just kept. I was very happy to see the result, and obviously all the counsel involved worked extremely hard, and it was just an incredible decision.
And it's nice when we get a decision from the Supreme Court that really clarifies the state of the law instead of making it more confusing. But this one was really very clearly written.
That's a good point.
But really, because sometimes some of them are a bit, make things even more confusing. This one was actually very clear. So that was really very nice to see in this decision. I want to thank you both for your time. And both of you have a lot of experience in this area, a very niche area, as you said, Emma, of youth justice. So thank you so much. And hopefully this will also help a lot of people who either do youth criminal justice or who are new into this area. This will really help them understand Section 72 moving forward. Thank you very much.
We definitely have to do, His Honor and I are co-authors on a book on youth justice, along with Sarah Lees and Mary Frizzell. Don't ignore our chapter on adult sentencing. It no longer applies. We will have to do a huge rewrite for the next edition. So yeah, don't rely on that section in the book because it doesn't apply anymore.
Although, just to mention that the Supreme Court did refer to that book in this decision. So, and to an article that was written by His Honor when he was a Crown, before he became a judge. So these are also important resources for anyone practicing in this area of youth criminal justice. Thank you very much, both of you. That was really nice.
Thank you.